This video presents a short list of tactics for experts to help you withstand cross-examination. The expert witness doesn't need to fear cross-examination if he or she has done a competent analysis, documented it well, presented it effectively on direct, and is aware of the opposing lawyer's tactics for cross-examination. Here are 21 tactics you can apply when you are on the witness stand under cross-examination. Number 1, be confident in your analysis and conclusions. You haven't ignored weaknesses in your opinion. You have considered them and incorporated them in your analysis. Be confident. 2, be thoughtful and scholarly. Don't be cocky or conceited. 3, maintain a calm, scholarly attitude toward the cross-examining lawyer. Next, in terms of respect and civility, don't treat the cross-examining lawyer any differently from the way you treated the examining lawyer. A different attitude toward the opposing attorney will make you look biased and argumentative. Be civil and respectful. 5, don't try to defend your analysis as though it's perfect. Expert analyses are never perfect, and you shouldn't pretend yours is. Number 6, maintain respect, but confidently defend your opinion. Number 7, don't be drawn into a staccato pace of cross-examination. This is a common tactic used by opposing lawyers, but use pauses before each answer to help control the pace, even though you're only defensively in control of the exchange. Number 8, don't be afraid to agree with opposing counsel if the question requires it. 9, if they catch you on a point, give it to them. It's foolish to try to defend something that's simply indefensible. Number 10, if you're asked to change your analysis based on a hypothetical fact, don't be a jerk about it. Consider including the word hypothetical in your answer rather than simply agreeing with the resulting change. Or you may choose to state something like, Mr. Attorney, the characterization of the facts in your question is simply inaccurate. 12, here's another response to a hypothetical. I'll be glad to answer your hypothetical, but it doesn't conform to my understanding of the facts. 13, if you're forced to answer an inaccurate question with a yes or a no, try this. A one-word answer would be misleading. May I have the opportunity to explain? Then the burden shifts to the attorney to either allow you to explain or be required to give what you've characterized as a misleading answer. 14, if a brilliant question is presented to you, don't hesitate to reply with an immediate lob, like, could you repeat the question, Mr. Jones? Or, I didn't exactly understand that question, Mr. Jones. Give yourself time to think without a long silence, or even a short one in front of the jury. 15, a tactful cross-examination will build up gradually, seeking agreement on small, obvious points, leading up to a seemingly logical conclusion that goes against your position. Without being argumentative, try to avoid agreeing with all the underlying points of the buildup as they are presented in anticipation of the closing question. 16, open-ended questions allow you to explain an answer, and good lawyers don't usually use them on cross-examination. But if you're lucky enough to be asked an open-ended question, take advantage of the opportunity to re-explain that part of your analysis. 17, if you have the opportunity to explain or re-explain an answer, try to do it through a calm, organized narrative that lays out the high points of your argument. 18, use an aggressive answer very judiciously. You may get an opportunity to take a swipe at opposing counsel, but do it very cautiously and infrequently. If you do it too often, it looks like you're being argumentative. 19, for any question that starts with, isn't it possible? The answer has to be yes. But the question is it reasonable or is it likely? 20, don't agree with a denigrating characterization of your analysis. For instance, so you just picked a number then, right? Or, after you glanced at the medical record, you guessed that enough time was not allowed for the procedure. If that happens to you, in your answer, politely disagree with the inaccurate characterization in the question and do it before you give the affirmation or denial. 21. If you're asked to recalculate or re-examine some aspect of your testimony, don't feel the need to do it hastily. If you require time to reconsider something, simply tell the court that you can't do this immediately in front of everybody. Ask to take a break and agree to return with the new answer to the information. Those are a quick summary of cross-examination tactics for the expert witness. Let me conclude with a summary of the categories and styles used by opposing lawyers to engage in cross-examination. Your understanding of these categories helps to ease the burden of cross-examination. Generally, cross-examination falls into one of the following 5 categories: lack of qualifications, superficial or incomplete analysis, the analysis was based on erroneous facts, the conclusions are incorrect, meaning a bad analysis or bad rationale, the conclusions are inconsistent with other analyses or testimony previously given. Now, there are also various styles of cross-examination. There's the friendly, I just want to understand what you did approach. Then there's the polite, we agree on a lot approach. Then the we have a few areas of disagreement approach. And of course, there's the direct confrontation approach, pointing out errors in the witness's analysis. This one is the most difficult to withstand, and it should be. You shouldn't have errors in your analysis. I can't help you much with that one. And then there's pointing out that the witness has relied on information from others that you have assumed to be correct. This one is easy. The expert should concede what she relied on, and if it's wrong, hypothetically, the conclusion is hypothetically wrong also. And finally, the boisterous, argumentative lawyer who disagrees with everything the witness says. These categories and styles are a comprehensive list of what opposing lawyers might ask you on cross-examination. Use these smart tactics to defend yourself and benefit your clients in the courtroom.
Brian Peter Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon. Professor Brinig is available for continuing education presentations and speaking engagements to professional groups.